Good afternoon, sir. Can you see and hear us?
Yes, thank you.
May we please call Mr. Bowyer?
I do solemnly,
I do solemnly,
sincerely and truly
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
and nothing but the truth.
Could you confirm your full name, please, Mr. Bowyer?
Yeah, it's Harry Bowyer.
Thank you for coming to the inquiry to assist it in its work. As you know, my name is Emma Price, and I will be asking you questions on behalf of the inquiry. You should have a hard copy of a witness statement provided by you to the inquiry in front of you. Do you have that?
I have that.
It is dated the 2nd of April 2024, and if you turn to page 32 of that, please. Does your copy have a visible signature?
It does.
Is that your signature?
It is my signature.
I understand there is a correction to the statement you'd like to make. Is that right?
Yes. I stated paragraphs 26 and 69 that I wasn't aware of the back door into the Horizon system until the Deloitte report. I've seen emails since which show that I was told about it in November 2012.
With that correction made, are the contents of that statement true to the best of your knowledge and belief?
To the best of my knowledge and belief.
That statement, for which the reference is WITN 109-90100, is now in evidence and will be published on the inquiry's website in due course. Starting, please, with your professional background. You joined Cartwright King Solicitors in the summer of 2008, is that right?
That's correct.
Having been in practice at the independent bar before that since 1990?
Yes.
Your practice at the independent bar had been exclusively criminal?
Exclusively criminal.
And you had been involved in both prosecution and defence work?
Indeed.
You say in your statement that when you joined Cartwright King, you were the first employed barrister in the firm, is that right?
Yes, it was.
But in the few years which followed, the firm expanded their advocacy department by employing a large number of barristers and solicitors with higher rights to cover almost the entirety of their Crown Court work.
That's correct.
Could we have on screen, please, paragraph 5 of Mr. Bowyer's statement? That's page 2. At paragraph 5, you say this: when I joined Cartwright King, they had 3 offices, Nottingham, Derby and Leicester. They embarked on a period of rapid expansion by acquiring other firms of solicitors. At their peak, they had around 20 offices from London to Newcastle. This involved a great deal of fairly ruthless reorganisation as they cut away the dead wood. Thinking back to the rapid expansion which took place, was the reason behind this that it would enable Cartwright King to prosecute post office cases in-house?
No.
No.
No, the expansion was at the time there was a proposal that legal aid firms would be limited to a very few in each legal aid area. And so what they were trying to do was put themselves in as many legal areas so they could bid for the contracts.
Did the fairly ruthless reorganisation you refer to have any impact on the post-office work which was being done at the time by the advocacy department?
I don't think so.
That can come down, thank you. Did members of the advocacy department prosecute post office cases in both the Magistrates' Court and the Crown Court?
There was quite a lot of work that was prosecuted in the Magistrates' Court and the Crown Court, but most of the Crown Court work went out to external counsel.
The advocacy department was based in the Nottingham office, is that right?
That's correct.
The head of department was initially one of the equity partners, Steve Gelsthorpe,
That's correct.
and then Andy Cash took on the role, followed by Mark Hopwell.
That's right.
You say in your statement that it was Andy Cash who introduced the then Royal Mail Group work to Cartwright King,
That's right.
and he was based in the Derby office but spent more time in the Nottingham office when he became head of the advocacy
That's
department.
correct.
Was there any provision at Cartwright King for training in relation to private prosecutions, and in particular prosecution disclosure obligations in private prosecutions?
There was very little.
Very little as in none, or
Well,
Some.
as far as I was concerned, the private prosecutions that they did was the Royal Mail work initially. They did some RSPCA work. And then Andy Cash brought in the poll work, I think, around about 2012. But as far as actual training is concerned, I certainly wasn't trained. And I don't know what happened to those who were doing the poll work, because it was being done in other offices apart from mine.
what were you told when you were first introduced to the Royal Mail Group and then later Post Office Limited work about the basis on which prosecutions were brought by the Post Office and the history of this?
I'm not sure I was told very much at all.
You were aware, though, that the Post Office was bringing private prosecutions.
Oh,
and that was
absolutely,
the work
yes.
that you were doing.
Yes.
At the time, did you recognise any risk arising from the Post Office being simultaneously victim, investigator and prosecutor?
Well, at the time, I wasn't really involved with it. If I'd addressed my mind to it, then yes, I probably would have seen the difficulties that you put forward. But the Post Office work that the Royal Mail Group work initially was tended to be postmasters or Royal Mail workers who were stealing from the post. And then in due course, the poll work was the work that this inquiry is in fact looking into. But as far as I was concerned, I didn't do very much of it at all until Andy Cash came into the advocacy department. And then he started to pick the brains of the various advocates there about various issues and would ask us to write the odd advice, charging advice, etc.
You address at paragraph 31 of your statement the training you received on the Horizon system. Can you help with when you received this training? Do look to the statement if you need to.
I can't recall. I think it would have been about 2012.
And you say that training did not cover the reconciliation of balances. What did it cover? Can you recall?
Well, I can't remember where it was. It was somewhere up north. But they had a Horizon system, and effectively myself and a number of external counsel were actually shown how the system worked effectively from a cashier's point of view.
Were members of the advocacy department responsible for keeping up to date with their own continuing professional development obligations?
To an extent, yes.
Was there any oversight of that by
Yes,
the
there
firm?
was. You had to show that you'd done your CPC.
You say in your statement that you were made a director of Cartwright King during the period covered by the inquiry.
Yes.
Can you recall when it was that you became a director?
I can't, I'm afraid.
You say you were one of around 30 directors. What responsibilities did you have as a director over and above those as a member of the advocacy department?
There were various responsibilities. File reviews was one of the main ones, so we had to review the files of other people in the department.
But you say you held no equity in the firm, is that
No.
right?
No, it was more of a reward that came up with the rations rather than a pay rise.
And you resigned from Cartwright King in December 2015, is
That's
that
right.
right? And what was the reason for your resignation?
Myself, Martin Smith, and Simon Clark wanted to set up our own business.
Is that something you went on to do?
That's something we went on to do.
Turning, please, to your involvement in the Royal Mail Group and later Post Office Limited work, and dealing first with the period prior to the interim Second Sight report coming to your attention in 2013. Could we have paragraph 8 of Mr. Bowyer's statement on screen, please? That is page 2. In the last line on this page, you say the RMG work was more provincial at that stage, but in 2012, Andy Cash brought the poll work into the firm, which was nationwide in nature. You say that the post office work was nationwide. Can you help with the scope of Cartwright King's instruction to act for the post office, and in particular, whether the general instruction of Cartwright King covered criminal cases in Scotland and Northern Ireland?
The answer is I can't help with that very much. We didn't tend to do Scotland and Northern Ireland. That was outsourced to other solicitors. Obviously, you've got the Scottish law problem, which none of us were capable of doing Scottish law.
Certainly by around 2013, that was a firm called BTO Solicitors.
Those are the ones, yes.
In Scotland. Can you recall the names of any other firms that were involved, either for Scotland or...
I can't recall. BTO was the one we dealt with most.
What was your understanding of the prosecution process for cases in these jurisdictions?
I didn't have an understanding at all, I'm afraid.
Looking then at paragraph 9 of your statement, you say the bulk of the poll RMG work was done by Martin Smith, based in Derby, and Andrew Bulk, based in Leicester. They would prepare the cases and brief them out to counsel. The RMG work involved some of the same type of cases as the later poll work, but also involved postmen stealing from the mail. And then at paragraph 10, when he was in Nottingham, Andy Cash would ask my opinion about the poll RMG cases, both informally, and on occasion he would ask me to settle an indictment or an advice on evidence. This would involve the file being brought to Nottingham so that I could work on it. It would then be returned to the lawyer working on it, and I would be unlikely to see it again, as it would usually be briefed out to counsel. So that's what you were referring to earlier in terms of cases going to counsel.
Essentially, yes.
In Crown Court work. You address a case you prosecuted involving a manager of a Crown Post Office at paragraph 12 of your statement.
Yep.
And you say it was a case that post-dated the cessation of prosecution of Horizon cases, and that it was a case that didn't rely upon prosecution Horizon evidence.
Yes.
With this exception, is it your evidence that you did not prosecute a trial?
I never prosecuted a trial for Post Office. I never had conduct of a prosecution brief as counsel or as litigator. I think I did a sentence in Nottingham because it was in Nottingham and that's where I was based. But apart from that, I don't think I did any other court work.
So this case at paragraph 12, when you say you prosecuted it, are you saying it's not one that went to trial?
It pleaded.
Okay, I understand. That can come down now, thank you. You say at paragraph 18 of your statement that your direct contact with Post Office personnel was fairly limited, but that you had dealings with Jarnell Singh, who you understood to be head of crime at Post Office Limited. who did you obtain instructions from at the post office?
Well, I wasn't actually, as I said, instructed in any cases. So I became involved either because Andy Cash would ask me to do something on a case or ask me my opinion about one of the cases. And I was also involved during the SIF process after the second sight review came out. But again, I would have been asked by either Andy Cash or Simon Clark to do the work that I was doing.
So in the instances where you provided written advice,
Yes.
were you not taking direct instructions from the post office?
No, I would be instructed from someone within Cartwright King.
I see. What was your working relationship with Mr. Singh like?
Pretty limited. I met him, I think, on 2 or 3 occasions. Once when Simon Clark and I went down to their Old Street offices in London, and a couple of times when he came up to Nottingham or Derby. And I spoke to him on the phone and emailed. Occasionally he would email with questions and the like, and I would respond. But the main point of contact between Cartwright King and Post Office was Martin Smith.
You say at paragraph 38 of your statement that you were aware from the beginning that the Horizon system was being challenged by the Sub-Postmasters for Justice group. By from the beginning, do you mean from the point that you became involved in any post office prosecutions relying on Horizon evidence?
Yes, I only really became involved in about 2012.
What about the system did you understand was being challenged?
I understood that there were allegations that it was throwing out false figures.
Did you consider at the time you provided advice on post office prosecution cases that you were under a duty to act as a Minister of Justice in preference to the interests of the client who had instructed you in relation to the prosecution?
Yes, certainly.
That this entailed observing the highest standard of integrity and having regard for the public interest?
Yes.
And that you owed a duty to the court to ensure that the proceeding was fair?
Yes.
Prior to being alerted to the content of the interim second sight report, did you ever question whether the evidence generated by the Horizon system could be relied upon for the purposes of prosecutions?
Yes, I mean, we were assured, and it was our instructions, that the system was robust.
And who did you ask, if you questioned it, whether the evidence could be relied upon?
The various caseworkers, the investigators that we're in touch with, later on the various post office lawyers that we came across. But there were all, I mean, one kept an eye on it because this was something that we were going to have to counter. So as far as allegations that the system wasn't robust, we were keeping our eyes out to see if there was any truth in it, if there were any patterns.
Did you receive assurances from John L. Singh?
I would have done, yes.
You refer in a number of places in your statement to assurances that you received from all sides that the system was robust and that there was nothing that could undermine the integrity of the system. Were these assurances ones given before the interim second sight report?
Yes.
In this period, that is prior to the interim second sight report, did you ever have difficulty getting information from the post office in relation to prosecutions?
Well, I was doing remarkably little of the work before the second sight report. So the answer is no. If I wanted information, I could get it. But as I say, I didn't hold the brief and I wasn't litigating the cases. It was a question people would ask me to advise on a certain part of a case. It may be that they wanted an interim advice or they may want an advice on a particular thing. It might have been that the advice that they asked for was verbal. I would be asked a question by Andy Cash and I would answer it there and then. But as I said, I wasn't actually working on these cases a very great deal. I had a full caseload of the defence work that I was actually employed by Cartwright King to do.
Could we have on screen, please, paragraph 21 of Mr. Bowyer's statement? That's page 5, towards the bottom, please. And at paragraph 21, you say this: "It is probably fair to say that the Cartwright King Post Office Department would have benefited from proper oversight from the earliest stages, from people with actual experience of prosecuting cases, rather than different individuals in different offices doing their own thing." What do you mean by different individuals in different offices doing their own thing?
Well, as I said, the bulk of the work was done by Martin Smith in Derby and Andrew Bulse in Leicester. When I was first aware of the post office work, I was aware that they were doing it and I was aware that they were briefing external counsel. I didn't realise that both had such limited prosecution experience at the time. And as far as that was concerned, that plainly wasn't a safe state of things. But I discovered about that much more when we were reviewing the cases and when we'd effectively stopped prosecuting cases.
Can you help with what you have in mind when you refer to proper oversight from people with actual experience of prosecuting cases?
Well, there are various things. Disclosure, of course, is a main one. Charging advice is a second one. As far as the two individuals who were preparing the cases, as I said, I don't think they had any experience of preparing prosecution cases until they were given this role at Cartwright King.
And who should have provided this oversight, do you think?
Well, it should have been someone, their head of department. Having them in different offices can't have helped. There should have been a post office department where they were in the same room, where they were actually able to pool what knowledge they had together. But that wasn't the case.
It may follow from your answer given just now, but was this lack of proper oversight something which you recognised at the time that you were doing post office work? I became more aware of it after the second sight came in and we were doing the SIFT reviews as to what was actually going on. But as I said, I was based in Nottingham. They were in different counties. Did you raise it at the time with anyone else within Cartwright King as a suggestion?
Not at the time, no. Because as I said, by the time it really became apparent, we weren't prosecuting anymore.
Could we have on screen, please, reference POL 00293276? This is a letter from Cartwright King to Roderick Williams from the Post Office. It's dated the 13th of January 2020, so postdates your departure by around 4 years. I'd like to ask you, however, about an observation made in this letter about the relationship between Cartwright King and the Post Office. The context for this letter is a review by Cartwright King of the work it had done for the Post Office since April 2012, which concluded that there were a number of improvements and changes in practice which could be made. And going please to point 3 on the second page of this document. The author says this: further to the 2 points noted above, we are becoming increasingly concerned at the somewhat disjointed way in which we presently approach poll work. This arises because there is no single dedicated point of contact within Cartwright King for Post Office Limited, as witnessed by the common use of CC'd emails to all 3 Cartwright King lawyers undertaking Post Office Limited work. The problem here is that a lack of continuity on individual pieces of work, together with a deficit in oversight over the landscape in which Cartwright King meets Post Office Limited requirements and advises thereon. In plain English, this means that there is an increasing risk that advice on one topic might fail to take into account the impact of that topic on another area of Post Office Limited work, with the consequent risk that Post Office Limited and Cartwright King are exposed. Of particular concern here is Post Office Limited's disclosure duties arising out of the recent judgment and the need to advise Post Office Limited on current and future Crown Prosecution Service prosecutions. Do you agree with the assessment here of the potential consequences of a lack of oversight, and in particular the risk that advice on one topic might fail to take into account the impact of that topic on another area of Post Office work?
Yes.
And would you agree that that risk was relevant to Post Office disclosure duties in 2012 and onwards, not just at this point in 2020?
Yes.
Is this the type of risk you had in mind when you flag up in the statement to the inquiry the lack of proper oversight?
Yes.
Is it a risk that you recognised at the time?
As I said, my appreciation of how Cartwright King were doing it increased when I got into the SIFT work, because that was when I was actually concentrating on reviewing the cases. But yes, it was plainly unsatisfactory.
That document can come down now, thank you. I'd like to move, please, to the advice you gave in the case of Kim Wiley. You deal with your advice dated the 11th of July 2012 at paragraph 39 of your statement, if you wish to follow. At the time of providing your statement, you had not seen your earlier advice, which is referred to in that July 2012 advice. The inquiry has relatively recently located that initial advice, and I understand that that has been provided to you.
I've seen it.
That is, in fact, dated October 2011 rather than 2010.
Yep.
I think that 2010 date comes from the date given in the July 2012 advice. Could we have on screen, please, POL 004 24121? This is the covering email from you to Robert Daly, dated the 28th of October 2011. Was Robert Daly the investigator in the case?
I'm very probably, but I can't recall.
It is copied to Rob Wilson, head of the Royal Mail Group criminal law team at the time, is that right?
I think so. I think this is probably still under the RMG umbrella.
It is also copied to Andy Cash and Rachel Panter. Can you help with what Rachel Panter's role was at the time?
Well, at the time, I wasn't aware of her role. She was based in Leicester with Andrew Bolse. She was, as I understand it, I think she'd passed her bar exams, but I think she was a comparative baby compared to the role that she appears to have been conducting.
Going then to the initial advice itself, could we have that on screen? The reference is POL 00424122. Can you help, having had the opportunity to read this document, with the purpose of this initial advice? And in particular, was it an advice on whether the prosecution test was met in the case?
Yes, having read it, I can see that there is no discussion of the evidential test or the public interest test, which, looking back on it, there should have been. It's not to say that I wasn't aware of those two particular issues, but I should have discussed them in the advice. It would have been an advice that would have been at the very early stages as to what the evidence we required and the charges that we should prefer.
You set out the prosecution case in the first paragraph, in that at the end of June 2010, Ms. Wiley received a letter informing her that Win Leighton Post Office would be migrating to Horizon Online. On the 9th of July 2010, she reported a 33,142.96 shortage in trading period 4. She could not explain how the shortage had occurred. The HOL advisor, Brian Cordery, reported concerns that he had been presented with money twice whilst conducting a cash check prior to migration. On the 10th of September 2010, an audit was carried out at Win Leighton Sub Post Office branch by Mr. Jed Dresser and Brian Marshall, Post Office Field Support Advisors, which revealed a deficit in the accounts of £5,434.93. There is then a summary of what Ms. Wiley said in interview, which included the fact that she could not explain the shortages as she hadn't done anything incorrectly. She says she was aware that the cash would be checked after she received the letter about migration to Horizon Online. She reported the cash shortage after receipt of this letter. And just going over the page, please. She denied theft and false accounting and cast doubt on the integrity of the Horizon system, blaming it for the error. You then say this of the defence case: the most obvious route for the defence in this case is to suggest that the Horizon system is flawed, or possibly that another member of staff stole the money. Just pausing there, this initial advice predates the instruction of Second Sight.
Yes.
You do not seem surprised in this advice that Ms. Wiley was blaming the Horizon system for the loss. Does that mean that this was not the first case in which you were involved, where a sub-postmaster was attributing a shortfall to the problems with the Horizon system?
Well, it was certainly within my knowledge that people were blaming the Horizon system at that stage, yes.
Can you recall how many cases of this nature you had been involved with previously?
As I said, very few at the time.
You deal with the statements which would be needed in the next paragraph. And at the last bullet point in this section, you say, we will need to prove the integrity of the Horizon system as there appears to be apocryphal evidence on the internet that it is causing big losses to postmasters. Can you recall what the evidence on the internet that the Horizon system was causing big losses to postmasters was?
I'm afraid I can't, but the sub-postmasters were making a lot of noise at this particular stage, and obviously we'd heard about it.
Can you recall the basis for your conclusion that it was apocryphal?
Well, because we had no evidence that the Horizon system at that stage was producing these errors, apart from the fact that people said it was.
At the time, did you consider the alternative explanation that those saying that the Horizon system was causing big losses might be right?
Yes, we certainly considered that, and we asked about it. But our instructions were that the system was robust.
You go on under discussion to conclude that the case could properly be charged as 2 counts of theft, and noting that the courts generally do not like theft and false accounting charges to be charged in tandem for the same course of conduct. And you cite there the Eden case. This was a case in which a sub-postmaster had denied theft and false accounting in interview and had raised the integrity of the Horizon system, blaming it for the error in interview, correct?
I can't recall. I haven't read Eden for 12 years.
Well, just going over the paragraphs that we have,
Yeah.
this was something that had been raised in interview by the
No,
sub-postmaster.
yeah, absolutely. Yes, of course.
There is no suggestion on the face of this initial advice, and I appreciate you may have had limited information at an early stage, but there's no suggestion here that there had been any investigation of whether the Horizon system was working properly in Ms. Wiley's branch. Would you agree with that?
Yes, and we're talking very early stages. This is an initial advice. I think the advice is dated, October, is it? And the audit was September.
In October, yes, to
So
October 2000.
we're at extremely early stage of the case.
Would you have expected the investigator in the case to look into whether the Horizon system was working properly in Ms. Wiley's branch?
I would have expected, as I said earlier in the advice, that we would need to show that the system was working properly.
It isn't something that you advised should be done in this advice. Can you recall whether there was any discussion about whether this should be?
I can't recall.
It was a reasonable line of inquiry, wasn't it, that should have been pursued, the issue having been raised in interview, as a line of inquiry which might point away from the guilt of the suspect. Would you accept that?
Yes.
Did you recognise that at the time?
Yes, I'm sure I did.
What did you do to ensure that that investigation happened?
Well, nothing, because I wrote this advice. It then went off to whichever of the CK solicitors who was prosecuting the case did, and I don't think I saw much more of it until Andy Cash asked me to do the second Wiley advice. As I said, this wasn't my case. I was asked to do the charging advice, but I wasn't in charge. I wasn't the file owner.
You've already recognised that there is no reference to the evidential or public interest tests for prosecution in this initial advice. What prosecution test were you applying when you concluded the case could be properly charged as theft?
Well, I would have had those two tests in mind. As I concede, there should have been discussion of those two factors in this advice. This advice, to that extent, is subpar.
Your advice in relation to statements which would need to be sought included you flagging up that we will need to prove the integrity of the Horizon system. Who did you mean by we?
The prosecution.
Did this include Cartwright King?
Yes.
Was it your view that if evidence of the integrity of the Horizon system overall could be obtained, then this would obviate the need for any specific line of inquiry as to the operation of Horizon in Miss Wiley's branch?
No.
Did you consider at the time of providing this initial advice what the Post Office's disclosure obligations were in the case in respect of other cases in which sub-postmasters were raising Horizon integrity issues?
Not at this particular stage, no, because, as I said, this is an extremely early advice. Statements hadn't been got in, and the initial bundle, I don't think, had been prepared, so no. But as I said, I wasn't running the case, and I wasn't responsible for the disclosure schedules.
As a general principle, at the time, would you have understood that sub-postmasters raising Horizon integrity issues in other cases might be disclosable in this one?
They might be disclosable, yes.
And what would it depend on the particular circumstances of the case as to whether they would be?
Well, it would depend on the defence raised in the defence statement. I know, obviously, in those stages, that stage, we were looking at obviously primary disclosure, which was matters which would undermine our case. And as I understood it at the time, there hadn't been a successful challenge of the Horizon system. We were not told about any bugs at the time.
Moving, please, to your advice in the Wiley case dated the 11th of July 2012. Could we have that on screen, please? The reference is POL 001-80894. And going first, please, to the bottom of the third page. We can see there the date of the advice, the 11th of July 2012, and your name at the bottom. Going back to the first page, please. You refer back to your initial advice in the first paragraph, and then you deal with the more recent events at paragraph 2, and you say this: the position of Post Office Limited has, up until now, always been robust. When the system has been challenged in the criminal courts, the system has always been successfully defended. I understand that the Post Office has announced that it has appointed independent forensic accountants, Second Sight Limited, to conduct an independent review of 10 cases based on the Horizon system. Whether this announcement was well considered or not is not an area that I intend to address, but the bell cannot be unrung, and there will be consequences that will have to be dealt with. Before we deal with the substance of this paragraph, I'd like to explore, please, what prompted this particular advice. Could we have on screen, please, POL 001-41393? This is a letter dated the 6th of July 2012. It is from Miss Wiley's defence solicitors to Cartwright King. And it reads: our client has brought to our attention that the Post Office management have decided to allow forensic accountants to examine Horizon. This decision appears to have been made after our client appeared in the Magistrates' Court for the first hearing. In view of the decision that has now been made, as of course our client is maintaining she has not stolen any money and that the fault is due to the Horizon system, what is your position with regards to how this matter is now to proceed? Clearly, we would submit that if the Post Office are now looking at the possibility that there may be an error in the Horizon system, then this case should not proceed further at this time. Perhaps you could advise us as to what stance is to be taken to enable us to consider matters further with regards to possible abuse of process, etc., arguments that may be advanced on behalf of our client. This letter predates your advice by 5 days. Were you advising in response to this letter?
I may have been. I didn't see the letter, but Andy Cash asked me to write the advice, and he may have been triggered by that letter.
Could we have the advice back on screen, please? It's POL 001 80894. Could we turn, please, to the third page of this document, which is subparagraph 6.3. And here you say this: we should ascertain why we have decided to instruct Second Sight Limited. I presume that it was not because of any doubt that we had in our system. If so, we should be robust in stating that is so. I presume our thinking was that as we have nothing to hide, we have no objection to our practices being scrutinised, in which case we should say so. Does it follow from this that at the time of providing this advice, you did not know the basis on which Second Sight had been instructed to undertake its investigation?
I didn't.
Did you ask for any information about the basis on which Second Sight was instructed from the post office before providing the advice?
I didn't.
Were you provided with any by anyone else?
No.
In circumstances where you were providing this advice, do you think you should have sought further information as to the basis of Second Sight's instruction?
Oh, in the light of everything I now know, then yes, certainly.
We will come on to the detail of your advice in a moment, but in general terms, you were advising, were you not, on the approach the post office ought to take to ongoing prosecutions which relied upon Horizon data. Is that fair?
Yes.
In light of that, do you think that you should have recognised at the time the need to seek more information before providing this advice?
Well, the difficulty is this advice is, I think, almost 12 months before the Second Sight interim review. And the forensic accountants of Second Sight, when they made their interim review, they came out with the fact that they could find no systemic fault in the Horizon system, and they came out with 2 bugs, and that was after a year of speaking to sub-postmasters, access to Fujitsu and access to post office. I don't see that I would have done very much better than they would have done.
Going back, please, to the first page of the advice at paragraph 2. Who was it who told you that when the system had been challenged in the criminal courts, the system had always been successfully defended?
I don't know. I think it might have been Andy Cash.
I'm sorry, can you say
It might have been Andy Cash, but I don't know.
This is a point which you list at paragraph 36X of your statement to the inquiry, in support of your understanding at the time that the Horizon system was robust. Did anyone tell you about the acquittal of Maureen McKelvey by a jury in 2004, Mrs. McKelvey having raised Horizon issues in her case?
If they did, I can't remember it.
Did anyone tell you about the acquittal of Suzanne Palmer in 2007, having also raised Horizon issues?
Again, if they did, I can't remember it.
Well, your understanding in both your statement and set out here seems quite clear that the message to you was the system had always been successfully defended.
Yes.
It was not a criminal case, but did anyone tell you about the claim brought by the Post Office against Julie Wolstenholme, which was settled in 2004 after a joint IT expert provided an opinion to the effect that the technology installed at the branch was clearly defective?
No, if they did, I can't remember it.
Also, at paragraph 36 of your statement, you say you were told that there were never any alleged surplus figures generated by the system.
Yes.
Again, can you recall who told you that?
It would have been the investigators or what I picked up from the people who were doing the post office cases.
Can you think of a single person who told you that?
I can't recall, no, but I can recall that was what I was told.
Similarly, at paragraph 36, you say that very few of these problems were being reported in Crown Post offices. How did you know that very few such problems were being reported?
Because again, I was told that, I think, by investigators.
Looking at the next line in your advice at paragraph 2, where did you get the information that Post Office had announced that Second Sight had been appointed to conduct the review?
Andy Cash.
And the last sentence in this paragraph, whether this announcement was well considered or not is not an area that I intend to address, but the bell cannot be unrung and there will be consequences that will have to be dealt with. What was your view on whether the announcement was well considered? It appears from this that you thought it was not. Is that fair?
I don't think that the announcement itself was a very good idea. I'm not saying that I didn't think the investigation wasn't a good idea, because obviously if there are people saying that the system is false, those particular doubts have to be chased. But the actual announcement of the Second Sight review led to various difficulties, people wanting to adjourn their cases until they had reported, etc. I think, in fact, in the Wiley case, there was such an application for the case to be adjourned until after the Second Sight report, which would have, as things turned out, been over 12 months hence.
Why would that have been a negative thing, people seeking to adjourn pending the outcome of an investigation into the system they were blaming for their losses?
Well, as far as that was concerned, it would have created a logjam. The position of Post Office was very strong. This system was robust.
Was your reaction to the fact of Second Sight having been instructed the same as your reaction to the announcement of it? As
No.
in, did you think that was negative?
No, if it were me, I wouldn't have done it. If I were the people that in charge of Post Office, I would have made absolutely certain through Fujitsu that the system was robust. I would have done an internal inquiry and made sure that Fujitsu could guarantee that there were no bugs that could cause what the Sub-Postmaster for Justice was complaining about.
Going on, please, to the next paragraph in your advice, that is paragraph 3. You say here, the first consequence is that we have now given ammunition to those attempting to discredit the Horizon system. The argument will be that there is no smoke without fire, and we would not have needed to audit a bomb-proof system. We can expect this to go viral in that any competent defence solicitor advising in a case such as this will raise the integrity of the Horizon system and put us to proof as to its integrity. As all of our cases depend on the system to compute the alleged losses, this is likely to affect a considerable percentage of our cases. You say in your statement to the inquiry that you have read the judgment of the Court of Appeal in Hamilton and others. Is that right?
I have.
At paragraph 137 of that judgment, and I don't intend to take you to it, I hope you'll take it
I'll take
from
your word.
me. There is a criticism that by representing Horizon as reliable and refusing to countenance any suggestion to the contrary, the Post Office was effectively seeking to reverse the burden of proof, treating what was not more than a shortfall shown by an unreliable system as an incontrovertible loss, proceeding as if it were for the accused to prove that no such loss had occurred. Is your concern here evidence of that approach, the reversing of the burden of proof?
I don't think so.
Does it suggest that you didn't think it would do for the Post Office to have to evidence the reliability of the data provided to the court in support of its prosecutions?
No, I suggested at this time that we needed an expert in order to demonstrate the reliability of the system.
This last line of paragraph 3, where you highlight that all of our cases depend on the system to compute the alleged losses, was this not a reason for you as a barrister advising on Post Office prosecutions to be concerned about the potential implications for those who had and were being prosecuted by the Post Office?
Well, of course it's a concern that the system is challenged, but there were at that time no successful challenges to it. Now, at that time, I hadn't seen and I hadn't reviewed other cases. But later on, obviously, I did get to review cases where there were experts who gave or who provided statements for the defence. And we did not actually have any positive evidence of the system not being robust until the Second Sight presented their interim review 12 months later. And that said that they found nothing systemic with the system. So even then, when we stopped the prosecutions, it wasn't because we thought that the Horizon system was not robust. It's because we thought we had problems with our expert.
Well, at this point in time, all you knew was that Second Sight had been instructed.
Precisely.
Without any information about the basis for that instruction.
Precisely.
And you didn't know what the outcome of the investigation was going to be, did you?
No, of course not.
So did you think, well, if the outcome of this investigation is that there's a problem with the system, a considerable percentage of prosecutions might have proceeded and might continue to proceed on the basis of unreliable evidence?
Well, that didn't concern me at the time, because we were going to get, my advice was we were going to get an expert who was going to attest as to the reliability of the system.
You go on at paragraph 4 to say this: the extra evidence which we will be obliged to gather will be as nothing in comparison to the potential disclosure problems that we may face. Until the Second Sight investigation is concluded, we will be in a limbo. One reading of this is that you considered the Second Sight investigation to be problematic because it might give rise to potential issues in relation to disclosable material. Is that the case?
Well, yeah, to an extent, yes, because obviously as far as Second Sight was concerned, it might raise stuff that was disclosable. But I don't think that I thought that it was going to produce material that was going to be of any relevance to the defence in future, because we were told in terms that the system was robust, and what we needed to do was get an expert to demonstrate that it was. Now, obviously, if Second Sight came back and they discovered faults, that was going to create problems in the future. But that's not what happened.
from the perspective of a prosecutor, is this approach not the wrong way round? In other words, if there was a possibility that an investigation might produce material capable of assisting the defence or undermining the prosecution, then that was a reason to investigate, not a problem.
I can see what you're saying. But as far as I was concerned, if we got an expert who was actually able to attest to the robustness of the system, and the expectation was that Second Sight wasn't going to find anything.
You go on in paragraph 4 to say this: it is essential that the inquiry is completed as soon as possible and we can live by its findings. We will have to find out when this inquiry will report in order that we can choose our strategy. If it is a matter of weeks, then cases can be put over until after it reports. If we're talking months, then the courts will not wear such delays. Might it not have been the case that a judge presented with a well-made application, supported by evidence, would have seen it as important to adjourn or stay proceedings pending the outcome of the investigation?
Well, that's certainly one point of view. It was plainly not my view at the time.
Mr. Bowyer, can I ask you, you're impliedly, if not expressly, critical of the Post Office decision to announce the Second Sight review. But in case X, shall we say, which comes to light, shall we say, 2 weeks after Second Sight has been instructed, and one of the first things that the prosecuting team sees is that the postmaster in interview under caution has blamed Horizon. Would the fact of the investigation then have become disclosable?
I'm sorry, sir. I don't think I understand the question.
Let me try again. We've got a case which comes to light shortly after Second Sight has been instructed
Indeed.
to investigate, and I'm putting this loosely, the reliability of Horizon within the terms of reference of the inquiry, all right?
Yes, certainly.
We then have a case in which there is an apparent shortfall as demonstrated by data from Horizon. And when the sub-postmaster is confronted with that in interview under caution, says, well, I can't explain it. It can only be due, however, to some fault in Horizon. Now, either as part of primary disclosure, but probably more specifically as part of secondary disclosure, would not the fact of the Second Sight review become disclosable?
I'm not entirely sure it would.
All right. I want your view about this, if I may.
Because the whole point of the Second Sight report being commissioned doesn't actually support a defence that Horizon doesn't work, because if the Second Sight report comes back and it says the system is robust, that doesn't support the defence. The fact that someone's investigating it is a worry, in that it does back up, as I say in the advice. There's a no smoke without fire argument, but there is no support for a defence by the fact that someone is investigating.
Remind me, is the test for disclosure that it does undermine the prosecution or support the defence, or that it may?
I think it's may.
Right. So on any view, surely if it's may, then it would be a disclosable document. Oh, sorry, not a
disclosable fact, certainly. Yeah.
Yes.
Yes. But the fact the post office had made the announcement meant it was in the public domain anyway.
Yeah, but that's what was intriguing me, that you appeared to be critical of an announcement which was, in effect, inevitable, since once there was a case, it would have to be disclosed.
You may be right.
Thank you.
You were in this advice advising on what the Post Office should do in relation to prosecutions going forward, relevant prosecutions. Would you accept that the question which mattered at this point was whether it was possible or fair to continue to prosecute whilst the second site investigation was ongoing?
Well, at the time, I thought it was.
I'm sorry, can you clarify your answer on that? You thought it was what?
I thought it was fair to prosecute if we got an expert demonstrating that the system was robust.
There's no express consideration in this advice, is there, of whether or not it was possible or fair to continue with prosecutions?
No, there wasn't.
Was there any assessment of that question in your mind at all, or was it a foregone conclusion that prosecutions could and should continue?
My view at the time was that they could continue.
At paragraph 5 of your advice, you say this: I assume that we still contend that the system is foolproof, in which case we should defend it aggressively. I understand that the manufacturers have not been helpful up until now. Had someone told you before you drafted this advice that the system was foolproof?
That was the impression that I'd got, yes.
Those are quite strong words, foolproof. Had someone else used those words in describing this to you?
I can't recall where I got it from.
Foolproof is very absolute, and you're making an assumption here that that was the Post Office's position. Given that the Post Office decision to instruct Second Sight to carry out an investigation into the system, was it a safe assumption to make about such an unequivocal position like this?
Well, with hindsight, no, it wasn't. But at the time, I thought it was.
You comment in this paragraph in relation to your understanding about the manufacturers not having been helpful up to now and would not provide expert evidence without large fees being sought. Where did that understanding come from?
I think that came from Andy Cash.
You go on, this will not do. If the integrity of the system is compromised, then the consequences will be catastrophic for all of us, including them. The financial consequences of convictions and confiscation orders being overturned and confidence in the Post Office bookkeeping being restored for future prosecutions will be astronomical. Did you understand at the time that if the system was compromised, then as a prosecutor, the overriding concern should be the impact that this might have on the fairness of past and present prosecutions?
Yes.
Is it fair to say that this advice does not read as though that was your overriding concern?
Well, as an exercise in reading the future, it actually looks fairly good. If the system was compromised, the consequences would be catastrophic, and that's what's happened.
Well, the last sentence here, you say they should be made to understand that this is a firefighting situation and it's not just our house that would be burned down if the system were compromised.
Yeah.
Was it your view that Post Office prosecutions were facing an existential threat?
If the system turned out to be compromised, then yes, it would have been disastrous for them. In fact, it has proved to be disastrous. That's why we're here today.
Did our house include Cartwright King?
No, it was Post Office. As far as Cartwright King was concerned, we were acting on instructions.
You set out a number of steps which should be taken at paragraph 6 of your advice, and we'll come to those in a moment. What we do not see here is an identification of the need for a reasoned and rational basis for continuing to prosecute cases using horizon evidence when an investigation into the system was ongoing. Is that fair?
That is fair.
Would you accept, looking at it now, that that was what was called for in these circumstances?
Certainly, with hindsight.
Was that something you should have recognised at the time?
Yes, as far as that was concerned, if I had my life all over again, I think the advice would be slightly different.
Miss Price, we need to take a break, so just choose a moment shortly, all right?
Yes, sir. That is an appropriate moment for the break, sir, if that's convenient. If we can
Yes.
have 15 minutes.
Yeah,
I'll make it just past 10 past now, so 25 past.
Yeah, certainly.
Thank you, sir. Hello, sir. Can you still see and hear us okay?
Yes, I can.
Mr. Bowyer, turning please to what you did advise in terms of approach, and at paragraph 6, Roman numeral 1. So if we can have that document back up on screen, please. It's POL 001808. There we are. 6.1, if we can go to page 3, please. Starting, there we are. You say, in my view, we should attend to the following. We should identify the contested cases, civil and criminal, in which the Horizon system has been challenged. We should identify the areas of challenge and how we neutralised them. Any expert reports should be retained for evaluation. An expert should be identified and instructed to prepare a generic statement which confirms the integrity of the system and why the attacks so far have been unfounded. This expert should be deployed in all cases where the Horizon system is challenged, and he should be prepared to be called to reply to defence experts on a case-by-case basis. To what extent was your advice here to obtain a generic statement influenced by your understanding in relation to how helpful the manufacturers had been in the past when it came to providing expert evidence, if at all?
I don't think it was influenced by that at all. The idea was that an expert should prepare a statement where the guts of it would be what has actually occurred in the past and what challenges have been made, and that they could comment on the particulars of the particular case that he was being served in.
Having had the opportunity to refresh your memory by reference to some of the correspondence which followed this advice, is it right that your advice led to the production of a generic statement in Gareth Jenkins' name?
It did. I wasn't happy with Gareth Jenkins because I didn't think he was independent, but I was...
We'll come on to that shortly. I think you've seen a transcript of the evidence given by Duncan Atkinson, King's Counsel, on the 18th of December last year. Is that right? He was asked a number of questions about your advice on expert evidence in the Wiley case. and more broadly. I don't intend to take you to the transcript, but if at any point you'd like me to, please do say, and we'll look to it. But I'd like to just run through some of the conclusions Duncan Atkinson reached. First of all, would you accept that what was in fact needed was case-specific expert evidence rather than a generic statement, even where the expert was prepared to be called to reply to defence experts on a case-by-case basis?
Well, the expert report should always be relevant to the case in point, but certain parts of it, rather like a drug statement, will remain the same. So if you are having an expert who is actually commenting on why the system is robust, what the attacks were made on it in the past were, and why they didn't actually have consequence, then that could be deployed in each case with reference to what happened in this particular case, because we had all sorts of different cases alleged. There were people who were alleged to be taking it out of the till. There were people who were alleged to be putting in PIN numbers. There were people who were alleged to be cross-firing postal orders. And so each case would be different. And the allegation as to why Horizon was not working would be different in each case. And that, as far as I saw it, was the way it would work. So the guts of the thing would be there, why it's robust, the attacks on the past. But he would refer to the case itself, otherwise it would be fairly useless in court.
Looking at the way that you have worded paragraph 6.1, which we've just been through, would you accept that this advice was seeking to protect the system rather than to assess the reliability of fundamental evidence in the prosecution of sub-postmasters?
No, I don't accept that. The advice was to say that the system was robust and respond to it. There's no protecting involved. If the system has got faults, they should be disclosed. The whole point was to actually put forward the attacks that have been made on it, and this would be an expert who could actually say the system was robust, and it was also a windmill for the defence experts to tilt at if they were able to actually come up, and the previous attacks on it would be helpful to the defence in that respect.
Was the purpose of advising that a generic statement for use in all Horizon cases should be obtained to obviate the need to investigate as a reasonable line of inquiry whether problems with the Horizon system might have created a loss, an illusory loss, in the branch of a specific suspect? Well,
no, because such a statement wouldn't in fact work in that way. If you were prosecuting a case, you would need to know. If I was prosecution counsel in an individual case, I would need to know why the defence suggestions weren't actually right, and so therefore they would need to be investigated by the expert on a case-by-case basis. I wasn't suggesting having a case to serve blanket in each case, because trial counsel wouldn't have wanted that. They'd have said, well, that's all very well in the past, but in this particular case they're alleging that this has happened. What about it?
Was the purpose of advising that this statement be obtained to obviate the need to identify material capable of undermining the prosecution case, or that if it was in the Post Office's possession, might undermine the prosecution case in any specific case?
No. The point of it was to actually address the system as to why it was safe, and as far as the defence were concerned, give their experts something to actually get into and give them an expert that they could deal with.
Looking please to paragraph 7 at the bottom of this page. You conclude, I can appreciate that the above might be expensive, but it will be as nothing should the integrity of the Horizon system be compromised. Taking a step back and looking at your advice as a whole, do you accept that there was too much focus in this on the potential fallout for the post office, Fujitsu and Cartwright King, if the integrity of the system was found to be compromised, and insufficient consideration of the implications for the people who had been and continued to be prosecuted on the basis of Horizon data?
No. What I was intending to do was actually create a situation whereby these cases could be prosecuted fairly, with proper disclosure to the defence. Our instructions at the time was that this system was robust, and as far as that was concerned, it would have been a pity if we didn't actually defend the system properly, because if a breach in the robustness of Horizon seemed to have been created, as far as that was concerned, that would have been disastrous. And so what we wanted to do was demonstrate that it was robust, and there was no covering this up. You know, as far as disclosure is concerned, we have always advised disclosure.
Could we have on screen, please, POL 001-43377? Starting, please, towards the bottom of this page. A little further down, please. This is the email from Andy Cash sending your advice to John L. Singh on the 11th of July 2012. He says he encloses advice from Harry Bowyer. I know it will be unpalatable, but for what it may be worth, I share his view. In the instant case, our response must be dependent on timescales for completion of the inspection. We are only just beginning to see these issues raised by defence solicitors, and the sooner we grasp the problem, the better. If you want any more, do call. Otherwise, I will await the outcome of your consultations before responding to the defence. And then, going further up, please, we can see the email above that in the chain, the email from John L. Singh to Andy Cash, copied to Susan Crichton and Mr. Flemington, dated the 16th of July 2012. And Mr. Singh says this: Andy, thank you. I agree defence will approach to stay the prosecution until the review by Second Sight is completed will become increasingly common. Post Office view is that such an approach be resisted. Review to be conducted is limited in scope in few and isolated cases. Second Sight would work with a number of MPs, two at present, to review cases that have been raised by their constituents. Second Sight's appointment is presently being agreed with the MPs and justice for sub-postmasters. There is no legal or forensic grounds to argue defendants will not get fair trial or abuse of process. There is no reason to justify the case being stayed. The fact that the review is being carried out is not an acknowledgement that there is an issue with Horizon. The system working properly and is being used up and down the country. When the system has been challenged in criminal courts, has been successfully defended. There is no mileage in this position, but is in fact superficial. This was a clear view being expressed by Mr. Singh that the Post Office would not agree to stay relevant prosecutions. Would you agree?
Yes.
And going up to the top of the page, we can see you were copied into Mr. Cash's response. And Mr. Cash says, thanks for this. Do we take it that we resist defence requests in the terms of your email? I would like formal confirmation, bearing in mind the view taken by counsel. If further consultation with Harry or otherwise would assist, please let me know. I will need to reply to Kim Wiley's solicitors this week. Did you understand these to be your instructions, that you should resist requests for a stay from the defence?
Well, as I said, I wasn't instructed in any of these cases.
Did you understand those to be Cartwright King's instructions from this email?
It seems fairly clear, yeah.
In respect of Mr. Singh's comments on your advice more generally, You say in your statement at paragraph 50 that you thought Mr. Singh was somewhat over-optimistic as to the limited effect of commissioning the second site review. Can you explain, please, why you say that?
Well, he thought that the second site review was going to be limited. I didn't.
Did you consider at the time that Mr. Singh was minimising the significance of second site's instruction?
I don't think I gave it that amount of thought, but actually, if I had addressed it, yes, I suspect that would have been my view.
At that time, did you have any reason to think that Mr. Singh was not being fully frank with you about whether there was an issue with the Horizon system?
At that stage, no, I had no reason to believe it.
You say in your statement that you were told by Andy Cash that the Post Office did not like your advice and that you were not asked to advise formally on the issue after that. What were you told about the reason why the Post Office did not like your advice?
Andy Cash, it was a throwaway comment from Andy Cash. They'd seen my advice and didn't like it.
I'd like to turn, please, to the generic Gareth Jenkins statement, which was produced following the July 2012 advice. Could we have on screen, please, POL 001 41416? This top email is from you to Jarnail Singh, copied to Andy Cash and entitled Horizon Integrity Project. So scrolling down a little, we don't see the sender at the top, but we do see Harry at the bottom there. It is responding to the email below from Jarnail Singh, dated the 6th of August 2012. Can we scroll down to that? Thank you. His email is to you, copied to Mr. Flemington, and he says this: Harry, it was good to chat with you. I confirm that Helen Rose has been given the task to gather the data. Please find her email and spreadsheet. It would be useful at this stage if you could look at what information Helen has provided and advise accordingly in readiness to instruct an expert as part of providing an advance pack disclosure. Below that is an email from Helen Rose explaining where her work, pulling together information relating to cases in which Horizon issues have been raised. And going back up, please, to the top of the first page, to your email. And you say, this appears to be what we want. Hopefully, Helen will confirm that the Horizon system has never been successfully challenged. I have yet to see any signs of experts briefed on behalf of the defence. When she has completed her exercise, she should prepare a summary of those cases where there is a proper attack on the system, rather than a gripe that the system is at fault, although she should record these cases so that we can say that they have been kept under review. They will become more numerous as the bandwagon picks up speed. The expert will need to address the report to the following issues. And you set out 4 points. A description of the Horizon system in layman's terms so that a jury can understand what it is and what it does. Second, a declaration that it has yet to be attacked successfully. Third, a summary of the basic attacks made on the system, concentrating on any expert reports served in past cases. If there are none, then state that no expert has yet been found by any defence team, civil or criminal, to attack the system. At the moment, there seems to be little more than griping by defendants that the system must be at fault without saying how. And fourth, plainly, like all accounting systems, there is room for human error, keying in wrong amounts, etc. But the expert should be able to state that innocent human error is unlikely to produce the types of discrepancies of many thousands of pounds over many months. A decent report along these lines will go a long way to putting this issue to bed. Can you help with why you considered the factual position on whether there had been an effective legal challenge to the Horizon system was a matter for expert IT opinion?
Well, I don't think I meant legal decision. I meant had there been an attack made by an expert on the system. Had there been any faults found? Had there been any faults suggested?
Well, Helen Rose was putting together a spreadsheet of cases based upon post office records,
Yes.
wasn't she?
Yes.
Can you help with why someone from the post office was not identified to give evidence about these previous cases or produce records of them?
Well, I assumed that the database that was put together would be something that would appear on the disclosure schedule and would be useful for a defence expert to look at.
Looking at the 4 issues you advised that the generic expert report should address, did you consider that these issues were sufficient to form the basis of a generic report on horizon integrity?
Well, I'm not a computer expert, so at this particular stage, I hadn't heard of any bugs in Horizon. And so what I wanted to do was actually take everything that there was that was critical of Horizon, because there was nothing from the post office side. And so the best angle, I thought, was the attacks that had been made in previous cases, because they would actually give the best in if there were any faults to be found with it.
These 4 issues do not actually address the fundamental question of whether a problem with the system could cause illusory shortfalls in branch, do they?
No, they don't.
Quite apart from the issue of whether a generic as opposed to case-specific approach was what was required, wasn't that the question at the heart of things?
You may well be right. Obviously, I'm not a computer expert, and so I went about it the way that I thought that the system could be best explained and best presented for the defence. Again, if I was able to write the advice in this email all over again, I may well have approached it differently. But at the time, I didn't know.
Towards the...
You can see it from the John L. Singh email, where he says it's robust. I mean, that's the information we got constantly at this time, that the system was fine apart from human error and manual entry mistakes.
Could we have on screen, please, POL 30020489? Towards the bottom of the first page, please, is an email from Andy Cash to John L. Singh, copied to you among others, and dated the 12th of September 2012. And he says this: Harry advises that the report, provided it is comprehensive, is what is needed, and we now need the expert's report on it as soon as practicable in view of the current case's timetables. The email replying to this is above and is from John L. Singh. And he says, Andy, thinking about choice of expert in this case, I have in the past instructed Gareth Jenkins of Fujitsu in the case of Misra, which identical was the only challenge on Horizon. He provided expertise in dealing with Defence's boundless inquiry into the whole Horizon system. Perhaps we need to reconsider whether to instruct him, as he may be viewed too close to the system, but instruct somebody entirely independent. Your thoughts, please, and also whether you or Harry have anybody in mind. And then you reply to this in the top email on the page, saying, I would have preferred someone entirely independent, but this is such a specialist area that we would be hard pushed to get a report in the timescale that we require. We might open our expert up to allegations of partiality, but his expertise will be unlikely to be challenged. We need to get this report off the skids as soon as possible, as we have PCMHs and trials galloping up on us. Was the urgency of the expert report being driven by the court timetabling in the case of Wiley and the other cases due to become...
It was a factor, certainly.
In this email, you express a preference for someone entirely independent, and you explain at paragraph 55 of your statement that this was because the potential for allegations of bias or actual conflicts of interest, as in the event were plainly relevant, were obvious. Can we take it from this that you were alive to the fact that Mr. Jenkins was not a functionally independent witness?
Yes.
Was consideration given at this stage to applying to adjourn these cases to enable time to find an appropriate expert other than Mr. Jenkins?
I don't think so, no.
Do you think consideration should have been given to that?
With hindsight, certainly.
You say at paragraph 56 of your statement to the inquiry that you were made firmly aware that finding another expert was impracticable. Who was it who made you firmly aware of this?
I was made aware by post office, and such proved to be the case when we actually tried to find another expert after Mr. Jenkins developed his problems. And so actually trying to find experts, I think Martin Smith and Simon Clark approached quite a number of people to try and get a report done on this case. And Post Office weren't helpful during that time, and actually finding someone with the expertise to be able to give a report on the Horizon system was very difficult indeed. But we certainly were not going to be able to do it in any short period of time, because obviously they had to be told what was wanted, they had to give their estimate as to what it was going to cost in order to provide such a report, etc.
Would you agree that Mr. Jenkins' lack of functional independence made it all the more important to ensure that he was aware of and understood the nature of expert duties?
Yes.
Could we have on screen, please, POL 30096997? Towards the bottom of this page is the start of an email from you to Martin Smith, dated the 2nd of October 2012, and entitled, as the chain of emails is, Horizon Fujitsu Report, Very Urgent. You are responding to an email from Martin Smith, which was forwarding on to you a report prepared by Mr. Jenkins in draft. And going to page 4 of this document, please, we can see an email further down in the chain, which was forwarded to you, an email from John Elsing, there we are, dated the 1st of October 2012, which was sent to Gareth Jenkins and copied to Penny Thomas, Hugh Flemington and Martin Smith. And we see there an introductory paragraph, and you, about halfway down, you will need to consider the disclosure officer's document spreadsheet, see attachments. That's the Helen Rose spreadsheet, and need to address in your report the following issues. And we see there, I won't read them out again, what looks like a copy and paste of the 4 points from your earlier correspondence. These instructions were contained in an email chain which was forwarded on to you when you considered Mr. Jenkins' draft. They are in effect the instructions to Mr. Jenkins. Did you consider these instructions sufficient for the instruction of a prosecution expert at the time?
Well, at the time I plainly did, yes.
Do you consider them sufficient looking at them now?
No, I didn't. If I went back knowing what I know now, then obviously I would I'd have done different.
Going back up to your email of the 2nd of October, please. That's the bottom of page 1. Going over to the top of the next page. So having been sent the draft report, you say at first sight these look like a good base upon which our reports can be based. As most our fishing expeditions, they will do in their current form. You say, I have edited the last report, last paragraph, because as it currently stands, it is an invitation for requests for further disclosure. See attachment. Can you put this past Mr. Jenkins? So dealing first then with the amendment you made to the draft, could we have the amended draft on screen? It's POL 30/58369. And this is the draft generic Horizon Integrity Report, which had been sent by Mr. Jenkins. And this version shows the amendment that you had made, referred to in your email. If we can go to page 9 of the report, please. This is section 3, entitled Horizon Integrity. Casting your eye down the page to see what's been taken out, we see a large chunk which has been deleted. Just scrolling further down, please. And over to the top of the next page. The change that you had made was to delete the reference to the Helen Rose spreadsheet and the summary of the specific cases which Mr. Jenkins had taken from that spreadsheet, as well as any reference made by Mr. Jenkins to specific cases. Would you agree with that
Yes.
as a characterisation of the amendment?
Yes.
Can you explain why that amendment was made?
Because this is effectively the basis of any statement made in a case. And as far as those matters are concerned, if you go back to the previous page, at the top of it, there is an awful lot there that would have to be changed every time. So HR spread, this is a spreadsheet prepared by Helen Rose, summarising 25 cases. As we went on, that number would have to change. It lists the number of cases that he didn't have anything to do with. And as far as this is concerned, it lists the cases that he did have something to do with, but there's nothing there that undermines the prosecution case in this. All of this would be disclosable, but would be stuff for a disclosure schedule, not for the statement itself. That's why I removed it, because all that would happen is we would be asked for vast quantities of paperwork in every case relating to these cases. Now, if they actually, as I said, none of it is primary disclosure, but later it will be secondary disclosure, and in due course they could get that from the disclosure schedule.
At the time, did you consider that it was appropriate for you to amend the expert's draft report?
Yes, I was asked to look at it. It would be absurd if someone couldn't put papers in front of their lawyers to say, is this right? And the amendments that I made, I then asked Martin Smith to put in front of Mr. Jenkins to see if he approved. The actual flavour of the thing is exactly the same. It says what Mr. Jenkins says, but it doesn't provide vast quantities of names of other defendants, which again, whether that's proper to put in a statement at this stage.
Did you ensure that the original unamended draft was recorded on the unused schedule in the case of Wiley or any other case in which it was disclosed?
No, because I wasn't actually litigating that case.
Can you help with whether Helen Rose's spreadsheet was treated as unused material, potentially disclosable in other cases?
I never saw the disclosure sheets.
Looking please to the last page of the draft report again. There's no expert's declaration on this draft report, is there?
Not that I've seen.
I think you've had a chance to review the document in its entirety ahead of today.
Yes.
Would you agree that it does not set out the substance of Mr. Jenkins' instructions?
Yes.
That can come down now, thank you. In your email to Martin Smith of the 2nd of October 2012, you asked that he draft generic Section 9 statements for Mr. Jenkins to produce the reports. Why was it that you considered that was the format that these should be put into, rather than a form of an expert report?
I don't know. That's what I decided at the time.
Did you at the time advise Mr. Singh or anyone else at Cartwright King that the report or statement needed to set out the requirements for expert evidence in criminal proceedings as required under the common law and the criminal procedure rules?
I don't know. I hope I would have done, but I don't know.
It may follow, were you aware at the time of the need for an expert to include a statement to the effect that the expert has complied with his or her duty to the court to provide independent assistance by way of objective, unbiased opinion in relation to matters within his or her expertise, and an acknowledgement that the expert will inform all parties and, where appropriate, the court, in the event that his or her opinion changes on any material issues?
Sorry, I don't understand the question.
I'm asking if you were aware that the wording I've just read out was a mandatory requirement for inclusion.
Yes, I was.
Can you help with why you didn't flag up, certainly on the email that we've just seen, the requirements for expert evidence?
I don't know. It was a work in progress.
At this point or at any other point, did you take any steps to ensure that Mr. Jenkins had been properly instructed as an expert
No.
and made aware of his duties as an expert?
No.
Can you help with why? Was it that this was someone else's responsibility, or?
Well, I wasn't, as I said, litigating the case, and I wasn't counsel instructed. But counsel instructed in the case would I hope, would have spotted if the expert's report didn't have an expert's declaration on it.
Could we have on screen, please, POL 30097216? This is an email chain from November 2012 containing emails between Rachel Panter, Gareth Jenkins, Andy Cash, John Elsing, and some others. Looking first, please, at page 3. This is an email from Mr. Jenkins dated the 27th of November 2012. And in the third paragraph, this is to Rachel Panter. You are not in the copy list of this at this stage. In the third paragraph, she says, reading through the Mr. Jenkins says, reading through the defence statement, I see it does make some specific points which my statement doesn't currently address, specifically the challenges regarding robustness and remote access to the system. Do you want me to try and address those specifics? Scrolling up, please, to Ms. Panter's reply on the same day. She says this in her first paragraph: many thanks for this. If you feel that you were able to deal with the issues of robustness and the remote access system fairly swiftly, then I would like you to address those points that have been raised so that we can deal with every area that they have criticised. Scrolling up again, please. We see an email from Mr. Jenkins. And he proposes adding in to the report some new sections. And he says, I've been asked to provide a statement in the case of Kim Wiley. I understand the integrity of the system has been questioned, and this report provides some general information regarding the integrity of Horizon. There's then reference to the robustness of Horizon in the next paragraph, including, I would say that Horizon has been designed such that it does not break down easily and is not affected by a single application failure. Also, Horizon does recovery quickly from failures and does hold up well under exceptional circumstances and is not wholly affected by a bug in one aspect of it. However, as the report below shows, that in those cases where there is a failure, the integrity of the data recorded is maintained and any discrepancies resulting from the failure are restricted to the transactions being processed at the time of the failure, whose amounts are normally insignificant compared to the amounts identified in shortfalls of cash as found during an audit of a branch. He goes on to address remote access. I also note a comment made about it being possible to remotely access the system. It is true that such access is possible. However, in an analysis of data audited by the system, it is possible to identify any data that has not been input directly by staff in the branch. Any such change to data is very rare and would be authorised by Post Office Limited. As I have not had an opportunity to examine data related to this branch, I cannot categorically say that this has not happened in this case, but I would suggest it is highly unlikely. Coming then to the email at the top, which is Ms. Panter's reply. She says, I have had our in-house counsel, Harry Bowyer, read this, and he is happy for all of it to go in, including the section about remote access. Harry has suggested that in order for us to deal with that potential avenue, that we ask the investigator to check if there have been any occasions where the system has been accessed remotely. Their findings either way can then be added in a further statement covering their lines of inquiry. So is Ms. Panter right that you read and approved the wording proposed by Mr. Jenkins that we just
She must be, yes.
You have this morning made a correction to your statement to the effect that the Deloitte report was not the first time you became aware that remote access was possible. Was it looking at this document?
It was looking at this document. This document dates back to November 2012, when the back door wasn't an issue that was bothering us. That became more live in July of the next year, some 8 months later. And I'd clean forgotten it. You can see with the Gareth Jenkins, Rachel Panter, he emails her first, I think, at about 12 o'clock, and her response is at 12:21. I have telephoned Rachel Panter, so I plainly wasn't close to my keyboard, so I probably read the email on my telephone. Responded that I was happy for it to go in, and suggested that we ought to cover whether it had been remotely accessed, and then I'm afraid I clear forgot about the whole thing.
Having had the opportunity to refresh your memory by reference to this document, do you now recall being made aware in November 2012 about remote access?
Not remotely. When there were a couple of shock moments in this as far as we were concerned. Number one was Second Sight, discovering that there were bugs. And the second one was the Deloitte report, which said that there was remote access, because by that stage Post Office had been quite voluble about the fact there wasn't. And this particular email exchange I just don't remember, because, as I said, my memory was the shock of the Deloitte report.
Does it follow from your answers that you don't recall feeling shock when you found out about remote access from Gareth Jenkins in November 2012?
Well, I don't think it was such an issue at that particular stage, because when we got into 2013, people were denying that it was possible. And it's when the Deloitte report came out that was proof positive that it was possible. And as I said, my reaction was shock in 2013, and I just didn't remember this exchange. I'm pleased to see that I actually advised disclosure of that, and I suggested that it should be followed up in the statement.
Do you think you understood the implications of this in November 2012?
No, I don't think I did. It was plainly disclosable, and that's why I advised disclosure. But it was the next year that the back door became an issue.
I'd like to move, please, to the second site interim report. Could we have on screen, please, paragraph 60 of Mr. Bowyer's statement, page 15. You say here, as far as Cartwright King's concerns with the second site interim report were concerned, we were very much alive to the fact that a system that we had been told was robust did indeed have bugs in it. This was plainly going to cause Post Office Limited difficulties. And at 61, I remember being taken aback when we discovered what the second site interim report would contain, as it flew in the teeth of what we had been told. Again, it was not of direct concern to me, as I was not a member of the Post Office Department. Do you mean the Cartwright King Post Office Department by that?
Yes.
You say at paragraph 14 of your statement that you became aware through conversations that Martin Smith had with senior Post Office Limited executives that the second site interim report would reveal the existence of bugs in the Horizon system. How long before the publication of the interim report did these conversations take place? Can you remember?
It happened at the very end of June, I think. What happened was Martin Smith reported to Simon Clarke that the second site report would disclose bugs. Simon Clarke actually had a post office case that he was prosecuting as counsel. And so he and Martin had a conversation with Gareth Jenkins, and I think the inquiry's got Martin's note of that particular conversation. As a result of that, Simon asked to see all Gareth Jenkins' previous statements, or a number of them, and discovered that none of this material had been made available there, which caused a worry about that particular witness. And that's what effectively inspired the Clarke report, which I think was about the 15th of July.
When Martin Smith was told that the interim report was going to make reference to bugs in the system, did anyone from Cartwright King ask anyone from the post office how long they had known about these bugs?
I don't know.
Did you?
I certainly didn't, but I came in later because I wasn't part of the telephone call to Gareth Jenkins, so that was Martin and Simon.
Did this make you question, when you got this message, whether Cartwright King would have been told about the existence of these bugs by the post office were it not for the impending report?
Yes, I mean, this, as I said, was one of the shock moments because a system that we were told was robust, whilst it didn't have anything systemic in it, did have bugs, and we should have known about them and we should have been disclosing them.
At paragraph 62 of your statement, you deal with the information you received about Gareth Jenkins' knowledge of bugs. And you say, this is the point at which you became involved. When I was approached by Simon Clarke, who told me about the conversation that he and Martin Smith had with Gareth Jenkins in late June over a case that Simon was prosecuting, the thrust of the conversation was that it was Gareth Jenkins who had provided the information about the two bugs mentioned in the second site interim report. This was clearly not consistent with statements that he had given in the criminal cases that he had been involved with. And then at 64, you address the implications of this. You say the implications of this were plainly enormous, and it was our joint view that Post Office Limited could not continue to prosecute on his evidence, and there would have to be a revisiting of previous cases with disclosure in mind. this was unlikely to be popular with Post Office Limited and our employers, Cartwright King. You say, however, that management at Cartwright King turned out to be supportive of your position. Is that right?
Yes. It was a nasty time because if they hadn't have been, it could have made our lives very uncomfortable.
Did it surprise you that Cartwright King management were supportive of your position at the time?
I was actually quite pleasantly surprised by it. I thought they were going to be more difficult about it.
And you say at paragraph 65 there that the matter was canvassed at the highest levels with the equity partners, as Post Office Limited was an enormous client even for a firm the size of Cartwright King.
Yeah.
And so was that part of the reason why you were pleasantly surprised, because of the significance of this client
Yes.
to the firm?
Yes. I mean, effectively, that was the stage that we stopped Post Office prosecuting, and we also were aware that there were disclosure problems as far as previous convictions. It may well be that Cartwright King are not covered in glory as far as their role as independent lawyers are concerned, but actually we did stop the prosecutions at that stage, and we did begin the disclosure sift.
You deal at paragraph 66 with the Post Office reaction to the interim second sight report. And you say that the Post Office Limited were philosophical in regard to disclosure of the second sight interim report to current and previous defendants. What do you mean when you say Post Office was philosophical in regard to disclosure of it?
Well, we made it clear that these, as far as the second sight interim report and later the Helen Rose report, disclosed stuff that should have been made available to previous defendants who had either been convicted or who had pleaded. And so Simon Clarke put in the SIFT regime. Post Office very shortly after that instructed Brian Altman, QC, as he was then.
Can you recall which individuals at the Post Office in particular were philosophical in this respect?
I think John L. Singh was someone I remember discussing the case with Simon and Martin.
You go on to say the attitude then was still that the system was essentially robust, and once the new expert was instructed, they could prosecute again. They were very concerned at the new cases being investigated piling up.
Yes.
What was the reasoning given by the Post Office for continuing to believe the system to be robust, notwithstanding the bugs which were identified in the interim second sight?
Well, the bugs themselves were identified by second sight as not being systemic. And so at that particular stage, the belief was that an expert who was reliable, was independent of Fujitsu, who could give the Horizon system a clean bill of health, would in fact fix the situation, and they would be able to continue to prosecute.
Did no one think, well, if there have been these two bugs, there might be others?
Well, to an extent, the second sight had been at this for over a year, and they had been, as far as we knew, in contact with Fujitsu, with the postmasters. They were forensic accountants. This is all they'd come up with.
Did anyone think there have been these bugs, there might have been others in the past, outside the period being looked at by second sight?
I don't know if anyone thought that, but as far as I was concerned, I thought the second sight had actually spent a fair amount of time doing this. But that was the whole point of getting the expert to take a look at the thing, to see if it was in fact robust, as Post Office said.
Can you recall who was expressing concern about new cases being investigated piling up?
I think that was Janelle.
Could we turn, please, to page 22 of Mr. Bowyer's statement? At paragraph 107 towards the bottom, please. In the context of a question about how the Cartwright-King review, to which we'll come, should have been done differently, you say this: plainly the review was conducted on the false premise that the only material that needed to be disclosed was the second site interim report and the Helen Rose report, when it must have been known at Post Office Limited and Fujitsu that the problems with Horizon ran much deeper. We were under the impression that whilst there were a couple of minor bugs revealed by second sight, and we had a problem with a dishonest witness, the Horizon system was fundamentally sound, and once that had been demonstrated by an independent expert witness, that prosecutions would proceed again. If we knew then what we know now, then there should have been a root and branch reappraisal of the past prosecutions and a complete moratorium on prosecutions based on Horizon until it could be demonstrated to be sound. At around the time of the publication of the second site interim report, you had been told that Mr. Jenkins was the one who had told second sight about the 2 bugs identified in the report.
That was my impression, yeah.
You were concerned, along with your colleagues, enough about his non-disclosure of bugs in the past that you considered the Post Office could not continue to prosecute based on his evidence. So in those circumstances, did you not question at the time whether there might be problems running deeper with Horizon, about which he and others were not being forthcoming?
Well, at the time, no.
Who was it at the Post Office that made the decision to cease prosecutions until another expert could be found, as far as you were aware?
I wasn't aware. I mean, it was as a result of Simon's advice.
Turning then, please, to the Cartwright-King review.
Well, hang on there, Miss Price. We're now getting close-ish to 4:30. What's the plan?
Sir, I think it's unlikely that I will finish this afternoon. I don't have much more, but I won't be finished by 4:30, I'm afraid, sir. We had envisaged going into tomorrow in any event ahead of Mr. Smith's evidence to deal with core participant questions, and so I wonder if it might be acceptable for me to finish my questioning in the morning before we commence that.
Yeah, well, subject to me just confirming with Mr. Bowyer that he's ready, able and willing, so to speak, to return tomorrow. I understand that's the case, is it?
Yes, sir. I indicated a while ago that I could come tomorrow.
Fine. So I think it is a convenient time to stop now. We've been working since 9:45. So overnight, please don't talk about your evidence. I'm sure you won't. And we'll resume again at 9:45 tomorrow. Thank you.
I'm blushing.
Thank you, sir.